Ecuador implementa una metodología de trabajo llamada Ruta Pro Ecuador para el exportador, para apoyar e incentivar el trabajo de todos los potenciales exportadores y de esta manera internacionalizar sus productos. Si posees un producto o un servicio y quieres saber si es apto para exportar, necesitarás iniciar en la etapa de orientación y asesoría, donde aprenderás cómo se desarrollan los procesos de exportación y conocerás las restricciones en los mercados internacionales. También tendrás acceso a talleres introductorios al comercio exterior, guías informativas, boletines de mercado y mucha información que te ayudará en el proceso para ser un exportador. En la siguiente fase de la ruta, recibirás la visita de nuestros especialistas, quienes evaluarán tu verdadero potencial de exportación para luego de esto acceder a la etapa de formación y asistencia técnica, donde ofrecemos capacitaciones especializadas y te vinculamos a proyectos como rediseño de producto acorde al mercado de destino, tu tienda virtual, coaching al exportador y diseño de empaques, herramientas que te ayudarán a consolidarte como exportador, incrementando la aceptación de tus productos, promoviendo así la cultura exportadora. Si ya estás listo para exportar o exportas, pero quieres conocer nuevas estrategias para diversificar tu mercado, la fase de promoción comercial te ofrece la posibilidad de mostrar tus productos internacionalmente a potenciales compradores mediante la participación en ruedas de negocios, misiones comerciales y ferias internacionales, contando permanentemente con la asistencia de nuestros especialistas sectoriales y red de oficinas comerciales distribuidas de manera estratégica alrededor de todo el mundo. Queremos que tus productos lleguen lejos. No esperes más.
Bienvenidos. Reciban un cordial saludo de todos los que conformamos el Ministerio de la Producción, Comercio Exterior, Inversiones y Pesca. Mi nombre es Lorena Conans y soy la Viceministra de Promoción de Exportaciones e Inversiones. Para mí es realmente un honor saludarlos e invitarlos a participar de los diferentes eventos de formación y capacitación que realiza este viceministerio a través de la Dirección de Balcón de Servicios al Exportador. Esta dirección, a través del área de capacitaciones, se encarga de brindar formación continua, totalmente gratuita y de excelencia para los sectores de la economía popular y solidaria, MIPYMES, emprendedores, exportadores y empresarios registrados en la ruta del exportador de ProEcuador y el público en general. Nuestra visión principal es fomentar una cultura exportadora, donde los participantes adquieran los conocimientos básicos, técnicos y avanzados necesarios para vincularse al comercio exterior y a la internacionalización de sus productos y servicios, obteniendo instrucciones claves sobre las opciones de financiamiento, requisitos generales para el ingreso a los mercados internacionales, costos y tiempos logísticos, principales impuestos, beneficios arancelarios, tendencias de consumo, entre otras temáticas de los países en los cuales ProEcuador cuenta con oficinas comerciales del Ecuador en el exterior. No se olviden de seguirnos en todas nuestras redes sociales. Esperamos verlos en un futuro muy cercano. Los esperamos.
Muy buen día con todos los asistentes. El Ministerio de Producción, Comercio Exterior, Inversiones y Pesca les agradece por participar en la capacitación virtual Negociación de contratos y términos de pago con compradores rusos. Este evento es coordinado y organizado a través de la Dirección de Balcón de Servicio al Exportador y la Oficina Comercial del Ecuador en Moscú, en coordinación con la firma legal RGP Legal. El objetivo del evento es que el sector exportador obtenga conocimiento sobre las mejores prácticas y consideraciones a tener al momento de negociar contratos de compra-venta con clientes rusos y aceptar pagos de dichas empresas. Está dirigido a exportadores. En el evento intervendrá el magister Ricardo Nicolás Falla León, consejero comercial de la Oficina Comercial en Moscú. Suren Gosunyan, Managing Partner de RGP Legal, y Marina Abasyan y María Schauber, Associate de RGP Legal. Información a tomar en consideración. Es importante recordar que puedan realizar sus preguntas a través del chat a medida que avance el evento y 15 minutos antes que finalice el webinar se dan respuesta a las inquietudes más relevantes. Solo estarán activos los micrófonos para los organizadores, coorganizadores y panelistas. A través del chat se remitirá el link de la encuesta de evaluación del evento. Solicitamos gentilmente la colaboración de cada uno de ustedes completando la encuesta que dura aproximadamente 2 minutos. Sus respuestas serán tratadas de forma confidencial y serán utilizadas únicamente para mejorar el servicio que le proporcionamos. De parte de este ministerio esperamos que el evento sea un éxito de su total agrado. Doy paso al magister Ricardo Falla León, consejero comercial de la Oficina Comercial en Perú, quien dará inicio a Moscú, perdón, quien dará inicio a la capacitación virtual, negociación de contratos y términos de pago con compradores rusos. Bienvenido, Ricardo.
Gracias, Cristian, y primero que nada, una excelente mañana a nuestros queridos exportadoras y exportadores en Ecuador. Un poco el objetivo del seminario el día de hoy es que conozcan de uno de los mejores grupos legales aquí en Moscú, justamente cuáles son esas recomendaciones y esas buenas prácticas cuando uno tiene clientes rusos, pueden que sean ya existentes o que quieran cerrar negocios aquí, sobre esas cláusulas, esos contratos que les van a ustedes tener muy buenas herramientas al momento de negociación y que obviamente tengan la mayor de seguridad al momento de hacer sus exportaciones a este mercado. Comentarios, como habíamos puesto en la capacitación, será dictada en el idioma inglés por la experiencia de la firma de abogados, ya que obviamente con el ruso un poco más complicado. Así que si bien voy a comenzar a hablar en inglés y dar la palabra al Managing Partner de RBG Legal, quien iniciará esta presentación. So, dear Soren, I was just giving a brief overview to the exporters we have today about where they're going to listen and get the advice from RGP partners. So with that, or without further ado, you have the word, my friend.
Thank you very much, Ricardo. Can everyone hear me? I hope they can. My name is Søren Gartsunin, as it was just said. I'm one of the founding partners and managing partner of Rybalkin Gartsunin Partners. It's a new generation Russian law firm that does deals, projects, and disputes from the Moscow office all over the place. All our lawyers speak English, as we'll try to demonstrate during the seminar. Some of them will present, and several speak Spanish. We deal with partners and clients from different countries, and for some reason, our Russian clients value our international experience, and our international clients value our Russian experience. Before I turn to the main subject of today's presentation, I would like to thank Commercial Office of Ecuador in the Russian Federation and Ricardo Falla personally for inviting us to speak in this lovely forum and making this event possible with very short notice. So I'm delighted to introduce my colleagues and our speakers today. Marina Bazian, she's an associate in corporate practice. Marina's presentation will concern general information contracts with Russian buyers and contractual mechanisms for protecting exporters. And Maria Schaubert, who is associate in our dispute resolution practice, in her part of the presentation will concern the content and scope of dispute resolution clauses in contracts, and this explain the basic difference between arbitration and litigation, and in Russian context, of course, and also provide a brief description of steps for bringing and defending a claim in Russian courts or in arbitration tribunal. We will also touch upon the settlements in US dollars, given that Russia also is a country where sanctions is an important word. So Russia is estimated to be approximately 22nd largest importer, and I understand that Russian imports are quite big, and Ecuador is the largest exporter of bananas in the world, and we also understand that Ecuador is also exporting a lot of roses to our country, for which we as consumers are very thankful. So our speakers today will aim to address the most common questions that come from companies that export to Russia, and we're glad that organizers have shared with us some of your questions. So we'll try to focus our discussion today around those issues. We're not aiming to deal with every aspect of international trade in this short aspect. So thank you very much. And at this point, I'll pass over to Marina, please.
Thank you very much, Suran. Um, Hi, ladies and gentlemen. My name is Marina Bazian. I'm a corporate associate at RGP, and I would like to talk to you about general like key elements of Russian contract law and measures to protect contractual measures to protect exporters. So on the first slide, we would start with some basic information on what to do, what to consider first when you start negotiating contracts with Russian buyers. Where first of all, it will be really helpful to conduct a quick due diligence of your counterparty. We have actually a lot of publicly available databases in Russia where you can find some information about the legal status of the company, like is it in bankruptcy or is it solvent or not, and also you can find information about the people who can represent the company without the power of attorney, which might be useful when you it might be useful when you check the capacity of the other party. Unfortunately, most of these databases are in Russian, although some websites are like have an English version, but the information that's contained in there is in Russian. So therefore, we would recommend that you ask like companies that you work with in Russia to help you with that. We can also provide you with such services. We do it on a, I would say, on a daily basis. So, and I can tell you this would save a lot of trouble so in the future. The second thing that you need to consider is the governing law, because depending on the governing law you would have a completely different packages of provisions that you could use, of contractual mechanisms like for protection, and different liability options. And I would like to note that in our presentation, we would mostly consider the issues related to Russian law. The next question to consider is the language of the contract. We received such question before the webinar, and it might seem simple at first, but in reality, what language would you use actually depends on a number of on the number of issues. And the first of all, of course, is the governing law, because of course, if you choose, for example, an English law, then probably making a contract in Russian wouldn't be a smart choice. And vice versa, if you're making a contract in Russian law, then most likely you would have to also negotiate it in Russian. I mean, most of the contracts, they are, of course, bilingual, so it would be useful to have a translation, but you should keep in mind that like there should be one language which is prevailing, which the court is going to deal with if you go to court afterwards. So you should consider this while deciding in which language you will negotiate the contract. My colleague Maria would actually further talk about it a little bit more in connection with the enforcement procedures, because the language of the contract might affect the process very much. Also, it depends on your bargaining position, of course, because if you are dealing with, for example, a big Russian retail chain, it might be difficult to negotiate a contract with them in other languages. So the next thing I would like to talk about is that the United Nations Convention on Contracts for International Sales of Goods, so-called Vienna Convention. So Russia is party to the UN Convention, and this convention has a direct effect, and and it supersedes national regulation, which means that that in certain matters, the Vienna Convention would apply where Russian national legislation wouldn't. So on the next slide, I would like to talk about key contract provisions that you need to consider while negotiating a contract with the Russian buyers. I mean, with any buyers, but most specifically with the Russian ones. So first of all, the contract should contain a detailed information on the type, quantity, quality of goods to be supplied. This is a material term of a supply contracts, and if the contract you're entering into doesn't contain this kind of information, then the court might consider that there was no contract at all. So it was not concluded because the parties didn't agree on substantial terms. Under Russian law, you can also have so-called framework agreement where you don't actually describe exactly the quantity and the quality of goods, but you said like you agree on general terms of the supply, and then afterwards you can just agree on the other material terms in specifications or like additional agreements to this framework agreement. This is a standard practice, and I'm sure most of you already work with framework agreements as well. The next thing is the delivery terms. Well, with the delivery terms, most important, I think, is to actually specify not only the measures, but also not only the logistics and the mechanics of the delivery, but also the mechanics of the checking the delivered goods, etc. I mean, in Russia, the standard practice would be to have a representative of the supplier when the goods arrive, so that they both can check whether the quantity and the quality actually is the same as they agreed on in the contract. And if it's not, then both the supplier's representative and the buyer's representative, they would sign a special act stating either the disagreement or agreement on the inconsistencies. The next thing I would like to the next thing that you should think about, of course, is the payment terms. Russian law doesn't contain any special requirements to the payment mechanics. It means that the parties, they are free to negotiate the payment terms any way they want. Another point that you should take into consideration is the transfer of title to delivered goods. That's important because it is related to the allocation of risks, related to the goods. For example, I don't know, if something happens and the goods are not delivered, and depending on at what moment the title was transferred to the buyer, either it would be the buyer's responsibility or it would be the supplier's responsibility. Like another set of provisions are the provisions on representations and indemnities. I must note that indemnities in the supply contracts are not so common, although depending on the circumstances, the parties can consider this as like a measure to protect their interests. On representations, I will talk a bit more detailed further. Then we will also talk a bit about contractual liability and amendment and termination of the contracts on the next slides. I would just like to quickly also mention that sometimes the parties, to kind of simplify the negotiations, may also apply Incoterms rules. And when you do that, you just need to keep in mind that they don't regulate every single detail of the contract. So even if you incorporate some Incoterms rules in your contract, you should still like regulate the other stuff. You should also agree on like other terms of the contract separately. So going back to the representations. Um, as I said, representations in a contract is also a measure to protect the interests of the parties. And in supply contracts, most commonly, like typical representations, they would relate to capacity of the counterparty, the legal status of the company, and compliance of the counterparty with law. So in case of any misrepresentation, you would be able to claim damages, or if the representation that was false was material for you, for example, if in reality the other party, like the buyer, didn't have a capacity to enter into agreement, and the representation turned out to be false, you may also have a right to terminate the contract. So the second, on the next slide, we will talk about contractual liability, which is probably I think the most interesting topic in terms of protecting exporters' interests. Generally, by default, a suffering party can claim for compensation of losses, specific performance, or payment of penalties. Well, if we talk about specific performance, this might be more applicable to the buyer's claim, not the supplier's claim, but I must note as well that it's this is only happening when it is possible, and most likely in the supply contracts, the buyer would just claim for losses because the specific performance wouldn't be possible. Talking about the damages, I would like to note that there are two types of damages by default that a suffering party can claim: direct losses and lost profit. So direct and actual losses is the expenses that the suffering party has incurred or should have incurred to remedy its rights, loss, or damage to its property. In 100%, almost 100% of the contracts, only direct losses are like allowed by the contract, but by default, a suffering party can also claim for lost profit. So lost profit is the income that was not received due to the breach of the contract by the defaulting party. So this is like a default rule, but the parties can also for example, exclude the lost profit from the damages that are supposed to be compensated, or also agree on additional terms for compensation of losses. The most difficult thing when when claiming for compensation is calculation of such losses. So our recommendation is actually to provide some basic provisions on how would the parties calculate the losses in case of a breach. So on the next slide, you can see some additional information about the penalties, because like it's I would say a common practice to also include additional penalties into a contract, especially when it comes to monetary obligations. And here I would like to note that there is also a default rule that says that if if the breaching party pays penalties, then the other losses may be recovered only in that part that exceeds the amount of such penalty. So in other words, if you have a loss, for example, for like $100, and the other party paid $70, you can only claim for like the other $30 and not another 100. But this is a default rule again, and the parties may agree on like different types of, I would say, different combinations. For example, the penalties can be payable on top of the damages, or they can be payable instead of the damages, or the creditor may be entitled to choose whether they want to claim damages or penalties. It is important to actually determine how the penalties would be calculated. It may be a fixed amount, or it may be a percentage of the value of the obligation. There may be penalty, for example, for each day of a breach. So that also depends on the parties. What you should keep in mind while actually agreeing on penalties is that the amount of such penalties may be decreased by the court if they are disproportionate. For example, if your loss was like for $100 and the contract provides for payment of penalties for $1 million, for example, then there's a good chance that the court would decrease the amount of penalties. Overall, I would like to note that there is basically like a general principle of Russian contract law that says that the parties are free to negotiate and agree on any terms they want. It's called the freedom of contract. So unless there are like rules that cannot be changed for. So you can see that, for example, in relation to penalties. Then on the next slide, we can see, we can discuss a little bit the alteration and termination of contracts. I'm not going to talk a lot about this, but I still would like to note just a few moments. As a general rule, a contract may be modified or terminated by mutual agreement. And this means that you would probably have to sign additional like addendum or additional agreement to the contract saying that the contract is terminated from like certain date, and also if there are some like obligations that were not performed, you may also agree on the way they should be performed or should not be performed, or if the other party should be released, etc. So it all depends on the parties. But there is, of course, a way to terminate the contract unilaterally uh, if if there are grounds for such termination provided by law or by contract. For example, if the other party, the buyer, is in breach, like a immaterial breach of its obligations, it gives the supplier a right to terminate the contract. Or maybe there are like special circumstances provided for in the contract. For example, the supplier has like an unconditional right to terminate the contract, like with a prior written notice or something, or like under certain conditions. In case that when you like these are the issues that you should actually consider when you are negotiating the contract. But if you already are party to contract, we recommend that you carefully analyze the provisions regulating such termination and alteration, and follow the procedure the way it is set forth by the contract. Because if you don't, then there is a good chance that the court would not terminate the contract upon your claim. I would also quickly like to talk about disruption of commercial contracts. So under Russian law, generally, you can limit liability of one of the parties, but unless 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 such liability is related to willful misconduct. And also, there are like certain circumstances provided by law where none of the parties shall be liable. For example, the force majeure. If like none of the parties shall be liable for any failure to perform or improper performance of its obligations, if it wasn't possible due to emergency or some kind of unavoidable events. Here you should note that, for example, if you have like a third party contractor or a supplier and such contractor or supplier is in breach, it doesn't mean that it was like an emergency or an unavoidable event. So this would not let you like get away with that. Or also lack of products on the market would not be considered as like such that kind of unavoidable event. And insufficiency of funds also wouldn't like let you like get away from liability. I mean, I think the good examples are, for example, like floods or earthquakes or this kind of stuff. Or also like the virus outbreak, as it was like before, like last year, I guess. And another concept that I would like to talk about is the impossibility of performance, because this concept also releases one of the parties from the liability. Like the obligations, they would be terminated if it becomes impossible to perform such obligations, and if like no other person would have been able to perform such obligations in the given circumstances. I think it also it might be also applicable to the export contracts, because I think my colleague Maria would talk more about this in terms of sanctions. So I'm not gonna go into details right now, but yeah, for example, if there would be like issued a governmental act or something prohibiting, for example, import of certain goods, then this may also be considered as like impossibility of performance. And another concept I would like to talk about is that the material change of circumstances. It's actually the last concept I'm going to talk about, so that I don't take too much time. Material change of circumstances is actually a very interesting concept that may be useful, and they may lead to termination of a contract or modification of such contract. So when you realize that the circumstances have changed that much that you wouldn't have even entered into such contract, and or you would have entered into such contract but on like substantially different terms, and you couldn't even have reasonably predicted such change of circumstances, then you could terminate such contract. If the other party doesn't agree, then what you do is that you go to court, and then the court decides if the contract shall be terminated or the contract should be modified. So I think I would ask my colleague Maria now to take the lead and talk to you about the dispute resolution matters. Thank you very much for your attention.
Hello, everyone. My name is Maria Schalbert, and I will cover the basics of dispute resolution in Russia that could be helpful for Ecuadorian exporters in the event of a contractual breach. I will start my presentation with dispute resolution clauses. So dispute resolution clauses are very important because they define the procedures that should be followed in the event of a contractual breach. Without such clause, you will find yourself in a problematic position where you simply do not know where to file a claim. You'll be asking yourself, should I file a claim in Russia? Should I In Ecuador, should I wait for a response from the buyer? If so, for how long should I wait? To avoid these difficulties, each contract has to include a dispute resolution clause. So what should be covered in the dispute resolution clause? Firstly, you should define the steps which need to be taken by the parties in an attempt to reach an agreement before submitting the dispute to litigation or arbitration. For example, you could say in a contract that the parties should try and settle the dispute through negotiations first. If after, for example, 30 days, such negotiations do not produce any results, the party can bring a claim to a local court or arbitral institution. So normally, negotiation requirements are not mandatory. It is up to you to include them or not, and this largely depends on your relationships with the buyer or any other contractual counterparty. Obviously, if you do not include negotiations in dispute resolution clause, you will be able to resolve the dispute faster. You can also include a provision which would require a party to notify the other party of the intention to initiate the dispute within a certain time frame. This might be coupled with the requirement for a party to present detailed descriptions of its claim prior to submitting a claim to litigation or arbitration. So, secondly, you should set out a clear time frame for each step. Again, if you want to include negotiation requirements, you should clearly specify the time frame. Otherwise, there is a risk of uncertainty as to how long you will have to wait before you can apply to court. Thirdly, and most importantly, you should pick the ultimate form of dispute resolution. For example, through local Russian courts or through arbitration. If you choose arbitration, you should also choose a seat of arbitration, the location of hearings, the set of rules that will govern the arbitration procedures, and well, that's the very least of the things that you should cover. And on the next slide, you can see actually a sample, a sample dispute resolution clause. In the interest of time, I suggest we move on to the next slide, as you will have the opportunity to review this clause in the PDF version of the presentation that will be circulated to you. So, what should you choose, arbitration or state courts? Let's start with state courts. This could mean either Russian state courts or state courts of Ecuador. I will note that I am not qualified in Ecuadorian law, so I cannot describe to you the procedural framework of Ecuadorian lawsuits. However, if you choose Ecuadorian courts as a forum for your dispute, you should know that you might experience serious difficulties with enforcing it in Russia. There is no treaty for mutual recognition of judgments between Ecuador and Russia, so it is very difficult, if not at all impossible, to enforce an Ecuadorian judgment in Russia. So if your counterparty is Russian and the property against which the decision could be enforced is also located in Russia, then Russian courts would be the most obvious option. But you should know that all proceedings in Russian courts will be held in Russian, and you will have to act through local lawyers and translators. The main advantage of Russian court proceedings lies in the fact that the judgment of a Russian court can be enforced almost immediately after it has entered into legal effect. The enforcement would be conducted by the Federal Bailiff Service, who perform the search for the debtor's property and seizure of such property. Once they collect the funds, they transfer them to you to comply with the judgment. The main disadvantage is that in practice, Russian courts have difficulties with understanding and applying foreign law. For example, if your contract is governed by Ecuadorian law or English law, you should definitely take this into account. Also, you will not be able to appoint a particular judge because all judges are appointed randomly. And you might get lucky and get a thoughtful and attentive judge, or you might end up with a judge who is rather passive and is not willing to examine the arguments of the parties very closely. Sometimes in practice, it might happen that the judge has already formed an opinion on the substance of the case even prior to the start of the oral proceedings, and this opinion might be very difficult to change. So let's move to the arbitration. Well, generally, arbitration proceedings are much more flexible than proceedings in state courts. There are many advantages. First of all, you can choose an arbitrator who will consider your dispute, as well as the procedure that will be followed. You can also select a place of hearing that will be convenient for you and your counterparty. For example, let's say you're in Ecuador and it's quite a long flight to Moscow. You can pick a location that's either in Ecuador, if it's fine with your counterparty, or somewhere closer to you. Normally, you rely on your local lawyers to help you pick up an arbitrator. We usually research all cases and backgrounds to try and predict how favorable the arbitrator will be to our potential arguments. So a lot of thought goes into this process of selecting the arbitrator, nominating the arbitrator. Secondly, the arbitrator of your choice might even be qualified in the law that governs your contract. And in any case, even if the arbitrator is not qualified in such foreign law, generally arbitrators are much more experienced in understanding and applying foreign law than Russian state judges. Thirdly, the proceedings can be held in English or in any other language, which is also quite convenient. The main disadvantage is that arbitral awards are not immediately enforceable. Arbitral awards, you still have to file an application with the state court for recognition and enforcement of the arbitral award. And only after this application has been granted, your arbitral award gets the same legal force, legal value than the decision of the court. In addition, arbitration proceedings might be more costly than proceedings in local courts. With arbitration, you have to pay registration fee, you have to pay arbitration fee, which covers the arbitrator's fee and administrative fee, the fee that the arbitral institution gets for organizational matters in relation to your case. And this is just without lawyers' costs. So yeah, and of course the fees differ greatly depending on the arbitral institution which you pick. So picking up LCIA or any other famously popular platforms might end up being more costly than picking some less known arbitral institutions. And let's move on to one of your key questions. How can you remedy a contractual breach? So let's say that Russian counterparty has failed to pay you for the goods that you have delivered. How should you proceed? The answer to this question depends on a number of factors. First of all, it depends on whether your contract or applicable legislative act provides for mandatory negotiation period or notification period. If yes, then you should comply with this requirement and send your counterparty a pre-action letter setting out your demands and the grounds on which they are based. Normally, in such pre-action letter, you would first describe when the goods were delivered with the relevant documents confirming this as an attachment. Then you would say that the delivered goods have not been paid within the agreed period of time. And lastly, you would set out your demands, such as, for example, compensation of the value of the goods and contractual penalty if your contract provides for a penalty. So after these steps have been completed, you wait for the response of the buyer and proceed with the negotiations until the mandatory period is over. And step two is, it depends on whether you have selected a forum in your contract or not. If you haven't selected a forum for your dispute in the contract, then the situation is a bit more tricky, as you will have to analyze which local courts will have jurisdiction to consider your dispute. And once you finish your analysis, you will file a claim with such court. If your contract has a proper dispute resolution clause, then the situation is much simpler and you should simply file a claim with the agreed dispute resolution body. So let's discuss in more detail the situation where you haven't selected the forum. It's the most difficult one. As a general rule, Russian courts have jurisdiction to consider a claim of a foreign claimant if the respondent or the property of the respondent is located in Russia. Thus, for example, an Ecuadorian company, you can file a claim with Russian courts even if you don't have a dispute resolution clause in the contract. However, you will have to hire Russian lawyers who will prepare the claim and make sure that it is consistent with formal requirements of Russian procedural rules. They will also present the case before Russian courts who only consider dispute in Russian language and in accordance with Russian procedural rules. You will then have to wait for the case to be resolved. If there are any appeals on the judgment, you would also need to wait for their resolution. Normally, Russian courts are pretty fast in comparison with other European systems. So it was reported in 2020 that the average time for a resolution of a simple civil law or commercial dispute is 50 days. Obviously, this may vary depending on complexity of your case. For example, it might take longer to resolve your dispute if the governing law of the contract is any law other than Russian, as you'd have to produce expert reports to Russian courts, which will set out the content of Ecuadorian law, and this will obviously create delays. Russian judge will then analyze this expert reports and make a decision based on them. Your opponent obviously will produce the report of their own. There might be conflicts between the two reports. So this is basically the reason why it might get a bit more difficult to finish it on time. Afterwards, you will have to wait for the bailiff service to enforce the award. As a matter of Russian law, judgments should be enforced within 2 months, but this term can be extended depending on circumstances. If you are dealing with a large retail chain, obviously it would be difficult to find valuable assets. The bailiffs would simply charge their bank account with the relevant sum, and that's it. But if your counterparty is a smaller scale buyer, then it might get a bit more challenging. On a related note, I also want to point out a few things which you should note when contemplating arbitration. Arbitration proceedings are very flexible, as I've already mentioned, and many factors depend on the arbitration institution which you have chosen to administer your case. For example, it was reported by the LCIA that the average total duration and the average arbitration costs remain at around 16 months and $97,000 respectively. Again, this does not include lawyers' costs, it's just arbitration fees. And again, as I mentioned, this might be different for other institutions. Many arbitral institutions offered expedited procedures for certain kind of disputes. Normally, it depends on the value of the claim. So, for example, Russian Arbitration Center provides expedited proceedings for claims not exceeding $500,000 US. And the duration of such expedited proceedings is usually much shorter. For example, under the rules of the same Russian Arbitration Center, they do not exceed 5 months. Again, this doesn't include the time which is necessary to recognize and enforce the arbitral award in Russia or other countries. As you know, Russia is a member of the New York Convention, so generally enforcing arbitral awards in Russia is not that difficult, just standard practice. And as a general rule, Russian courts grant such enforcement within a month from receiving the relevant application, but delays are possible depending on complexity of the case and whether or not your debtor filed any objections to enforcement of the award. For example, in my practice, we had a case where we were trying to enforce an award in Russia for more than 2 years. So it really does depend on the circumstances. But if it's just like a more simple commercial dispute, it shouldn't be very problematic. And you should, of course, carefully review the arbitration rules and the fee schedule, which the relevant arbitration institution publishes on their website prior to selecting them in your contract. Finally, moving on from the topic of dispute resolution, you have asked the question about sanctions, namely whether the sanctions affect Russian companies making transfer in US dollars to third countries, including Ecuador. And the short answer is yes. Wire transfers in US dollars are cleared through US banks, and US banks cannot allow such transfer from a sanctioned person or to a sanctioned person. They can't allow such transfers to proceed, and they have to block them. So, of course, this is a major obstacle. But obviously, this restriction applies to those Russian companies that are on the US SDN list. This actually quite helpful because not that many companies are there. These are usually companies which deal with security and things like that. So thankfully, not that many companies have to deal with this kind of difficulties on everyday basis. So I think this sums up my presentation, and I would pass the word to Seren Gertunian, our partner.
Okay, thank you very much. Maybe if you can switch the next slide, whoever is taking care of that. Ricardo, I think we promised, yeah, this is the right slide. We promised to take 3 questions from the audience. And I was, while you are assembling those questions, I was just willing to briefly tell about the firm. Of course, there will be information provided in the presentation, which will be circulated after the webinar. But I wanted to say that we're a sort of unique type of Russian law firm where most of the lawyers, or at this point, I think all of them, come from the background with major international law firms. The founding partners, Mr. Balkin and myself, we were partners at an American law firm for over 8 years prior to establishing Russian firm, and both have practiced in Russian market for over 20 years. And we do have a selection of talented and senior lawyers who will be able to assist with various questions. If you can also switch the next slide while we're taking questions from the audience. Thank you.
Perfect, Suren, Marina, and Maria. Thank you so much for your intervention, your thoughts, your recommendations to our company. I think they're quite valuable. And I'll start with the first question, especially what you mentioned, Marina, about force majeure and the time that we're living with COVID-19, but also note that we have seen the problems with the shipping containers, the rising price in certain type of raw materials that are later used. Could you, and also to ask, what has the Russian courts or the Russian legal system said about if COVID-19 or the disruptions that we're seeing in trade right now, can they be used to say it's force majeure? What are your thoughts on this question?
Well, thank you very much, Ricardo. That's actually a very good question. We've been analyzing the court practice and the developments very carefully during the last year, because, of course, with the virus outbreak, it became like the #1 topic for the all commercial contracts and people who deal with commercial contracts. And I can tell you that there is there was no unified approach, because it mostly depends on the circumstances and the contractual provisions, because it depends how it is specifically regulated in the contract, because in some cases it was considered as a force majeure, but in other cases it wasn't, because it really depends on the circumstances. So if any of anyone who's participating in today's webinar has a specific question relating to their situation, we would be of course happy to analyze their case and go back to them with a more detailed response. But the short answer is that it really depends, because Russian courts, they tend to consider force majeure those events who are specifically listed in the contract. If you list it in the contract, then most likely it will be considered. But you also have to consider the fact that last year, in 2020, it was really an unpredictable event and some kind of emergency. So it was easier to consider this as a force majeure back then rather than now, because now when the parties are negotiating their contracts, they should also already keep in mind that this virus outbreak is not gone yet, and it's not some kind of a new and unpredictable event. So now if there is a new contract that parties enter into, then the court would most likely to not consider it as a force majeure if the parties specifically didn't list it in the contract, and they just go to court and say, oh, okay, we didn't expect that that this would last for so long. So yeah.
Perfect. No, thank you so much. It gives us quite a very good insight to that perspective. And maybe for you, Maria, when you were touching upon the mediation in the contracts, maybe on your experience on the recommendations on the law firm, especially for those companies trying to make a decision whether to go through arbitration, maybe with a Russian arbitration center and international arbitration, or maybe put clauses that they say that they'll go directly into court. Do you have any insights or recommendations to see what should a company consider first when drafting a contract?
Well, this is a very good and difficult question, of course, because it largely depends on your expectations or your need on your counterparty in terms of how powerful it is. Sometimes it also depends on how much experience you have with Russian courts, whether you have trusted lawyers and advisors who can represent you, because arbitration is obviously simpler in terms of two parties are truly equal in that sense. And unfortunately, this might not always be the case with Russian courts. So yeah, this might not always be the case. And actually, it's quite difficult. I would personally recommend arbitration probably, because it's usually simpler for foreign buyers, foreign exporters as a platform. It's more familiar. It allows you to conduct the proceedings in your own language or in English, whereas Russian courts are quite difficult, might be quite difficult. But again, this depends on the complexity of your case, because if you have a really simple case, or you have all the documents which straightforwardly points to the fact that this retail chain hasn't paid you for the goods which you have delivered, and they have accepted this goods without any kind of comment, without any objections, then it might be quite easier and maybe even cheaper to do this in Russian courts. But again, this really depends on the circumstances of the case and your history and experience with this particular counterparty. So there can be a decision which would suit everyone. This depends.
And just a quick thing regarding if they decide to go to arbitration, should they choose an arbitration center or entity here in Russia, or is it recommended to be a third party in a third country? Any thoughts on that particular aspect?
Yeah, maybe I can contribute on that question. First of all, in the choice between arbitration and the domestic Russian courts. Domestic Russian courts, as Maria said, are quite efficient. They are quite quick, but the proceedings there will be usually public, as opposed to arbitration, which you can try to keep confidential. But the main choice is usually I've been asked this question for many years, and obviously the parties, they consider the value of the contract. They consider the assets of the counterparty, whether there are any prospects of enforcing, if it's an international arbitration, any of it abroad and outside of Russia. And the third aspect is finality. If you would ask me to summarize in one word, what is the difference between litigation and arbitration, this word will be finality. Because when you do an arbitration, it's very difficult to expect this procedure, this procedural work to be reviewed. It's only for very limited number of reasons. Then you can review this this decision. While in the state courts, although it's quicker, then there are stages, and you can go through appeal and sort of another appeal, and then go to higher instances. So overall, the process is probably the same, and the cost of going through an arbitration, a complex arbitration, or sort of going through all instances in the state courts is probably going to be the same. But finality is something that makes it different. So that's first part of the question, and the second part is whether it's recommended to go to international arbitral tribunals or domestic Russian ones. Domestic Russian ones are quite developed, and actually they have, some of them have quite reputable lists of arbitrators. So the most important ones are ICAC, International Court of Arbitration under the Russian Chamber of Commerce and Industry. And then this Russian Arbitration Center that we mentioned. There are probably others as well, but they're more subtle points than that in selecting between Russian and international arbitration centers, because the cost is probably a bit cheaper in the Russian ones. The quality you can expect will be higher in international ones, but the cost will be much higher. And obviously the enforcement, as Maria mentioned in her presentation, is another aspect that you have to face in any event. So these are my comments. Maria, if you want to add.
No, I think you summarized this perfectly. Just that, yeah, you have a lot of factors to take into account, and obviously Russian Arbitration Center is much cheaper than, say, LCIA, but of course the quality might be different. But still, it might be a good option to consider, less known arbitral institutions for the purposes of drafting dispute resolution clause.
They will all have quite developed set of rules, and as I said, a lot of the arbitrators, it's like the persons who will actually be considering the dispute, they can actually be the same. That's why it's a tricky question that you're asking, Ricardo.
You always have to ask the tricky questions to the lawyers. They always come with a good answer. And for the final question, the last portion of the presentation that you were mentioning about sanctions, a more specific one. What happens whether, of course, the company over here is not in the sanction list or on the OFAC, but what happens if the bank they use, to give an example, it's VTB Bank. That VTB Bank is under the OFAC list. So if they have a bank account with one of the Russian banks that is under the sanction list, when they try to make the wire transfer, it'll get like, it won't be accepted by the Ecuadorian bank. If it exists payment issues connected to that particular areas, can you protect yourself within the contract, or is it considered a force majeure as well? What are your thoughts on these aspects?
So just a general reminder that there are sectoral sanctions, and then there are individual sanctions. So individual sanctions, this SDN list, they are actually extremely strict. So they prohibit any transactions for U.S. persons with anyone who is on the SDN list, and then also there is this issue with secondary sanctions. But with in the case of VTB Bank, it's on sectoral sanctions list, so it's not on the so-called blacklist of effect, and which is where the problems come up. And so using VTB as a bank doesn't really create much risks. in that level. But on the other hand, as regards your question about sanctions as force majeure, this is actually a really good and again quite controversial question, because the practice of Russian courts in this respect differs greatly. There are judicial decisions which consider sanctions as force majeure event. I mean, when I'm talking about sanctions, I mean any kind of export restrictions, not just restrictions with the use of the dollar and things like that, just export restrictions. So they might be considered force majeure, but then there will also many cases where the courts refuse to consider them as force majeure. And the situation really depends on how much you are affected by the sanctions. For example, it's one thing if as a result of sanctions, certain company simply cannot import the goods, simply cannot do any kind of transaction with certain types of goods. That's one thing. And that's completely different thing if, as a result of sanctions, the company just experiences serious financial difficulties. They have many of their accounts blocked, and this results in their inability to pay. In the second scenario, it might be quite challenging to prove that this is indeed a force majeure for Russian courts, because they might simply refer to the Russian legislation, which expressly states that inability to pay does not create a force majeure event. And that is basically the reason why this might be difficult. So to sum up, the answer is, as always, it's complicated and nuanced. You have to analyze many aspects when trying to build your case on whether or not sanctions create force majeure events. It's not that straightforward.
No, perfect. I think we have a better understanding now about a little bit about the Russian legal system, contracts, arbitration, sanctions. So I want to thank you so much, Suren, Marina, and Maria, for your time today. I'll just give some final remarks in Spanish to our exporters. But first, thank you so much again for your time. Y a nuestros exportadores y exportadoras que nos están viendo de Ecuador, esperamos que este seminario haya sido de su ayuda, que esta información que también vamos a compartir, la presentación, sea de su uso para que cuando tienen negociaciones con clientes rusos o están revisando el tema de contratos, puedan tener estas consideraciones para que haya los menores riesgos posibles al momento de hacer transacciones internacionales. Así que con eso, de nuestra parte, nos despedimos desde aquí, desde Moscú. Nuevamente, muchas gracias por su tiempo. Igual a los colegas del Ministerio en Ecuador, muchas gracias por su ayuda en esta organización.
Muchas gracias por su atención.
Gracias, Suren.
Thank you.
Muchas gracias.
Thank you so much.
Gracias.
Gracias, Suren, Marina, María y a la Oficina Comercial del Ecuador. Muchísimas gracias por esta participación. A los usuarios se les indicará que la información del video y la presentación se les hará llegar de 5 a 7 días por correo, luego de finalizar este evento. Muchísimas gracias y tengan una excelente tarde.